This is Colin O'Keefe here for LXBN TV. Last week, in a major ruling, the Sixth Circuit Court of Appeals upheld same-sex marriage bans in 4 different states, setting up the possibility that we may soon see this subject back before the United States Supreme Court. Joining me now to explain the ruling and offer his opinion on what might be next is attorney Steve Delchin. He's with Squire Patton Boggs, an author on the firm's Sixth Circuit appellate blog. Steve, first off, let's start with the ruling at hand. Can you explain to us just what happened with this ruling? I understand it wasn't unanimous.
Hi, Colin. It's good to be here again, and you're absolutely right. As I covered on our blog last Thursday evening, the Sixth Circuit's panel decision upholding same-sex marriage bans in Ohio, Michigan, Kentucky, and Tennessee was a divided 2-to-1 decision, with Judge Jeffrey Sutton writing the majority opinion. And what a majority opinion it was. 42 pages long and unusually philosophical. Now, you asked about the rationale behind the Sixth Circuit's decision. Well, Judge Sutton did not offer a rationale. He offered no less than 8 rationales or justifications as to why the U.S. Constitution does not require states to change the traditional definition of marriage. Judge Sutton addressed everything from originalism to fundamental rights theory to the notion of a living and evolving constitution. You know, reading Judge Sutton's opinion actually brought me back to a philosophy of law class that I took in college. Very philosophical. Now, one of Judge Sutton's primary rationales in his opinion is a structural one. It's based on the fact that the Sixth Circuit is bound by U.S. Supreme Court precedent. Back in 1972, the Supreme Court in Baker versus Nelson issued a 1-line order holding that a gay couple's challenge to a Minnesota state law banning same-sex marriage did not raise, quote, a substantial federal question. Judge Sutton said that the Sixth Circuit is bound by the 72 order because the Supreme Court has never overruled it and because summary decisions are binding on the Sixth Circuit. Judge Sutton also rejected the argument that last year's Supreme Court decision in United States U.S. versus Windsor somehow overruled the 72 Baker decision. As some of your viewers may know, the court in Windsor last year struck down part of the Defense of Marriage Act of 1996 because the federal act refused to respect state laws permitting gay marriage. In striking down part of the act, the Windsor court never mentioned Baker, much less overruled it. So the natural conclusion for Judge Sutton was that the Sixth Circuit panel could not ignore a Supreme Court decision. It had to follow precedent. Of course, this is one of the raging debates over Judge Sutton's opinion. In her dissenting opinion, Judge Martha Craig Daughtry dismissed the 72 Baker decision as a, quote, dead letter that lacks only a stake through the heart. So you can see how the battle lines are being drawn. Now, a second rationale supporting Judge Sutton's opinion was his unremarkable conclusion that the rational basis test applies to same-sex marriage bans and that such laws easily pass muster under this exceedingly lenient standard for evaluating discrimination claims. Indeed, the definition of marriage as between a man and a woman is one measured not in decades or even centuries, but in millennia. In Judge Sutton's view, federal courts should be very, very hesitant to condemn as irrational a view of marriage that not long ago was shared by every single society in the world. And along the same lines, Judge Sutton also rejected the suggestion that a fundamental right to same-sex marriage exists in the Constitution. He refused to emanate in the penumbras of the Constitution to extract such a right. Now, Colin, I'm sure by now you are saying the philosophy of judicial restraint pervades many aspects of Judge Sutton's opinion. It's clear that Judge Sutton believes that the judiciary should not act as some kind of super legislature on social policy. Sutton's opinion is worth the read because they'll give you a nice preview of all the various legal arguments for and against gay marriage bans. These are the same arguments we'll see in the amicus briefs that will be filed if this case does in fact go to the Supreme Court. So lots of different arguments. But the bottom line takeaway from last Thursday's opinion is the majority's conclusion that the plaintiff simply had not made the case for constitutionalizing the definition of marriage and removing the issue from where it properly belongs, which is to them, the voters of each state.
Absolutely. And you mentioned the key thing here is many people are wondering if it's going to go to the Supreme Court. You mentioned the dissenting opinion that the previous Baker decision is really only lacking, as a dissenter put it, a stake through the heart. So now many people are wondering if we will indeed see that stake through the heart. But so what are your thoughts? Is this something that will likely go up to the Supreme Court? We've seen a lot of courts disagreeing on this subject, and oftentimes when that's the case, that's where it heads next. So do you see it going there?
Colin, the general consensus among court observers is that the Sixth Circuit case is definitely headed up to the Supreme Court. And that's really because we have something today that we didn't have last Thursday, and that's a circuit split, and a stark one for that matter. The Sixth Circuit's gay marriage decision last Thursday created a direct conflict with decisions from the 4th, the 7th, the 9th, and 10th circuits on the issue. So we have a 4-to-1 split. And we didn't have this split back in October last month when the Supreme Court denied requests to take up the gay marriage issues. A lot of people were surprised that the Supreme Court stayed its hand last month, but I didn't find it surprising. I think it's apparent that the court was waiting to see if a circuit split would emerge. And now we have it. And I'll also say, I think the Sixth Circuit itself views its case as heading to the Supreme Court. Judge Sutton seemed to be writing his opinion in an effort to appeal to Justice Kennedy, who likely will be the swing vote if the case makes it to the high court. And in that respect, Colin, let me leave you with what may be the ultimate irony. Okay, consider that Judge Sutton's majority opinion is a very elegant defense of the doctrine of judicial restraint. But his opinion likely may be the catalyst that not only spurs the Supreme Court into accepting gay marriage, but also issuing a judicially active opinion that creates new constitutional rights. In other words, it's possible that the Sixth Circuit's decision just nationalized gay marriage. But we'll let your viewers debate that one. Yeah, I would submit that the legal battle over gay marriage is not over. And in fact, we should be gearing up for it at the Supreme Court this year. If the Supremes do take the case, look for an opinion by 2015, or June 2015.
Absolutely. It's going to be fascinating to watch. As you mentioned, as soon as there's a circuit split, that's when people immediately go, oh, this is headed to the Supreme Court. And it's very funny, the irony you mentioned, that wanting to go against judicial override may have just set himself up for just that. So it's going to be very interesting to watch to see which way it goes in the end. Once again,
and we'll be following it.
Absolutely. Once again, that was Steve Delchin of Squire Patton Boggs. For more of his insight on this specific case and other issues coming out of the Sixth Circuit, be sure to visit sixthcircuitappellateblog.com. Thanks for joining me today, Steve.
Colin, thanks as always. See you soon.